a reminder, and then I'm going to take you through some scenarios. So the first question we had was, you mentioned inheritance tax keeps changing. Where can you find the updated details? I did think I did answer this last time, but usually at the time of the budget, whether that be in March or November, they generally announce changes to the inheritance tax rules. Present rules can be found at this link that I've put on here, which is basically via the government website. And if you want to know what kind of changes are proposed, so there's likely to be an overhaul in inheritance tax. So inheritance tax actually hasn't changed for some time. It was, I think, 275, the nil rate band was 275 in 2009, increased to 325 and has stayed until since then, so a very long period of time. But they're looking at overhauling it, including business property relief and those types of relief. So if you want to just kind of see what suggestions are being made, if you go to the Office of the Tax, that's supposed to say simplification, consultation, you'll be able to find out the forthcoming changes. Second question was, please remember that if IHT, well, it was more of a statement, please remember that if IHT applied, then there will be the need to obtain probate. That process for even a relatively simple estate can take a long time. Some of you may not be familiar with the term probate. So once someone has passed away, if they have bank accounts or a property, well, certainly if they have a property, in order to sell that property, you will require a grant of probate in order to sell that property. Now, even if you have a will, you will still need a grant of probate to sell a property, and sometimes even access money in bank accounts if they're over a certain amount. So individual financial institutions will say, you know, if a bank account has, say, £50,000 in, before they release those funds, even if you have a will, they say, well, we need actually a grant of probate. That is basically a process by which you apply to the probate registry in order to get the grant, so then you can sell a property on behalf of the estate. So it's the executors that apply for that, and also close bank accounts. So it doesn't necessarily matter whether there's IHT or no IHT applying. You may need it even if there is no IHT applicable. Clearly, if there's inheritance tax to pay, the first thing that has to happen is that once you've got all the information together, the forms go off to HMRC, they rubber stamp that document to say that you've paid the correct tax, and then you apply for grant of probate. And then I think this person is alluding to the fact that that can take some time. Timescales vary on the complexity of the estate, but certainly over 6 months. Please, could you say something about a deed of variation? Again, this the reason I didn't mention any of this is because this occurs after death. So once somebody has passed away, a deed of variation is a document that allows the beneficiaries named in the will to change the distribution of the estate. So there's a will, it says something, and then basically the beneficiaries, along as all the beneficiaries who are going, you know, who it's going to make a difference to, can agree to vary the will. What they could be deciding to do is basically say, for example, say 3 people are going to inherit. One of the 3 people can actually say, I don't want the money, I want it to direct it to my children. And the reason that they do that is because if they inherit it and then gift it to their children, it counts as part of their estate, and then they have to survive the 7 years for it to sort of not be included as part of their estate for inheritance tax. In these scenarios, you know, we would be suggesting that once somebody has passed away, you always seek advice. It's a very good tool to have in order to direct money away from your own estate to someone else, perhaps to give it to charity, or, for example, if a child was left out of a will and the other siblings would now want to include that child, the will could be varied to do those sort of things. Is there space available and discount for DBWS members if Farida takes up the case? Unfortunately not. I'm an employee for a firm, so I don't have discretion over fees. They are set by the firm. There's either a fixed fee, so if you're just making straightforward mirror wills, for example, my firm charges £350 plus VAT. For a single will, £195 plus VAT. More sophisticated wills can be up to £1,000, sort of £1,100 plus VAT. Really does depend on your circumstances. And then anything more complex, where we're sort of inheritance tax planning, preparing trusts, will be based on hourly rate, either mine or whoever you instruct. But when you go to any firm of solicitors, they will always tell you their fees up front. So you'll never be shocked or surprised by it. Well, you might be shocked by the price initially, but you won't ever be surprised at what you have to pay, because we have to be clear on our fees. Okay, so today really what I wanted to stress is this topic. I mean, wills and estate planning is such a vast area. It's complex. The idea is to try and get you as individuals to be thinking about your own estate planning. As I mentioned last time, a will is bespoke, it's tailored to your circumstances. Everybody's family situation is different, everybody's assets are different, everybody's motivations are different. So an individual like myself will meet with you and we will tailor your estate accordingly. So although we can give you an overview in this, we can't cover every scenario. I think the message I would really like you to take away today is that if you don't have a will, get one and get appropriate advice. If you already have a will and you have not reviewed it in the last 5 years, you need to review it. When you go for a will review or to put a will in place, that solicitor will then review your entire situation. So your business assets, if you have any, your pot of money, your financial advisor, work along with accountants, all essentially becomes a part of a package. And then it will suit your circumstances in terms of what advice you're actually given. I think I did mention this, but I just wanted to stress it again, that please steer away from do-it-yourself wills or online wills, or where you're not actually getting professional advice. So if you remember why I did mention to you why you should make a will, I'm not going to labour the point too much, but it's to ensure that people you love and care for will be supported after you die. If you want to ensure that you leave your estate in the way you want to, a will make sure that it certainly does that. It provides clarity, and it also gives you control over your affairs, you being the person that's made the decision of how your estate is left. Clearly mitigate inheritance tax. And again, we mentioned succession and bloodline planning, which essentially meant if you have businesses, they can be left in a certain way to children. Bloodline planning is also about, you know, if you have children from other marriages, although you want to look after your spouse, you want to make sure that your children from both marriages or relationships are looked after, and it also avoids potential disputes. So just to help people understand what estate planning is, it's basically an umbrella term, and it encompasses all these things that I put in here. So wills being the main factor, business succession planning. I'm going to talk about long-term care planning because I know people are concerned about that. We talked about trusts, sort of setting up trusts in your lifetime to perhaps mitigate inheritance tax. So move money into the trust so it's no longer part of your estate, but you're not gifting it outright to anyone. So it's protected in this trust, and then you can dribble it to charities or children or grandchildren, however you want it to be looked after. And obviously, Ghazala Ben has mentioned lasting powers of attorney, but again, that's about planning and making sure that not only you have the peace of mind, but your family have the peace of mind that should you lose capacity, the people you trust will be able to look after your affairs. So basic recap, I mentioned what is a will. It's a legal document that comes in effect after you die. And again, I don't intend to labour that point. And we also spoke about what was to be included in a will. I think I just wanted to just kind of, over the first couple of points, just stress that an executor and trustee can be the same people, and it can also be the same people as beneficiaries. You don't have to have different individuals. You will sometimes have different executors and trustees to beneficiaries if there's likely to be any conflict between beneficiaries, or obviously in the situation where you have only minor children, you're not going to appoint them as your executors and trustees. And I think guardians for minor children, that's so important, because you've really got to consider who you would want to look after your children if both parents died while they were in their minority. So what I was going to do is actually, I'm just going to mention this issue initially. I think a lot of people don't realize this, is that if you are what they term as common law marriage, there's no such thing as a common law marriage. So if you live together with someone or cohabit and you're not husband and wife, you won't have the same legal rights as married couples, and therefore the partner will not inherit your estate on death. Now, a lot of people don't realize that even though you've had your nikah done, but not actually had a civil marriage by English law, so you've not, gone to the local registry office and done your civil marriage, your nikah will not be recognized. You will actually be counted as cohabiting partners, and actually your spouse by Islam will not inherit your estate, and actually make it very complicated for them to benefit. So it's important that if you don't have a civil marriage here, get one. And if you can't do that, then obviously make a will. I mean, priority is to make a will anyway. I think I also mentioned briefly to you last time about where a spouse doesn't inherit. So if you were cohabiting partners and you left your estate to your cohabiting partner, and your estate was above the nil rate band, which is £325,000, anything above that would become taxable. So actually, it's quite important that you do consider, if you're already married Islamically, you won't have any issues getting married by the law of the land, and that will enable you to transfer your assets to your spouse free of inheritance tax. So I'm going to give you some scenarios and we're just going to run through them. And like I said, the point is I didn't want to then, last time I think what happened was there's probably too much information. This is kind of giving you scenarios so you can kind of think about some things that might suit your own circumstances, which you may not have considered. And actually, when you go to see your solicitor, you can actually talk about them yourself. So this is a situation where we have Yahya and Hawa, who are married and have no children, but they also have no wills. They own a house as joint tenants worth £650,000. They have savings and investments worth £200,000, all held jointly. They own a joint property in Spain worth £100,000, and they also have a Persian rug worth £50,000. Hawa dies in 2017, and under the intestacy rules, because she has no will, the law says that Yahya inherits her entire estate. That's fine and works. But what happens next? Yahya then dies in 2019, still having made no will. So because he inherited everything from Hawa, his estate is worth £1 million. We know he has a nil rate band of £325,000. He never made any lifetime gifts to anyone, and Hawa's estate entirely went to him. So he also gets to use her nil rate band. So the estate at the date of death has a combined amount of £650,000 before any inheritance tax is payable, which means that on £350,000 at 40%, the estate will be paying £140,000 in tax. Now, you might not be concerned about that, but that's a lot of tax to pay. So who will actually inherit Yahya's estate, because he has no will? Like I said, the law governs who inherits under the intestacy rules, and actually it will be according to an order. So if it will be Yahya's parents, if both of them are alive, both will inherit equally. If one of them are alive, one of them will inherit. If you remove that layer, then it's siblings of the whole blood. If you remove that layer, it's the children of siblings of the whole blood, and then it goes down. Ultimately, if there was no one there, it would be the crown that inherited. Clearly, Yahya would want certain people to inherit his estate. It might be charities, it might be people that have helped him through his life, it might be his siblings, we don't know. But until he makes a will, it's actually the law that will direct where his money goes. So what could Hawa and Yahya have done to mitigate inheritance tax? So we know that in terms of their estate, it was worth £1 million. So they could have given, that £200,000 is actually a wrong figure, but they could have gifted a certain amount of the estate to charity, which would be above the 650. So it'd be quite a large amount, £450,000 to charity, and that entire amount would be free of inheritance tax. And then they can leave the £650,000 to specific individuals if they wanted to. Or if they actually want to just reduce the amount of inheritance tax, they can give 10% of the estate. So 1.2 million pounds, 10% of that to charity. And they would only have to pay, well, they would have to pay a reduced amount of 36% as opposed to 40%. So they're things that they could have done. We have another story of Onslow and Daisy. They are married and have 2 young children. Onslow's 38 and Daisy's 36. In terms of their assets, they own their own house as joint tenants, which is worth £600,000 and a mortgage of £100,000. So Onslow's share of equity in the house is £250,000. Onslow has savings of £50,000. He also has premium bonds of £25,000, and he has a life insurance policy which is payable to the estate. Unfortunately, Onslow dies young, and he dies without making a will. What will happen to Onslow's estate? Because there was no will, Daisy keeps, and the law says what happens, Daisy keeps all the assets, including a property up to £270,000, and all personal possessions, whatever their value. The remainder of the estate will be shared as follows. Daisy gets half of the remainder, and the other half is then divided equally between the surviving children. So if we look at the breakdown of their estate, Daisy will get half of the property, so she'll have her own half, and she'll also inherit Onslow's half because it's worth £250, plus she'll also get the £20,000 of savings, which will give her the £270. Everything else that's left, we've got £100,000 in life insurance money, £30,000 in savings, and £25,000 in premium bonds. That will actually be divided between half between Daisy, and half between the children on attaining the age of 18. In this situation, clearly, because Daisy is young, she could have benefited from that extra nearly £80,000 in bringing up her children, managing her own affairs. But the will can't be varied. We mentioned the deed of variation because the children are in their minority, so it will have to stay as it is, and Daisy will have to struggle through. A worse scenario in this situation is where there's actually inheritance tax to pay. So say Onslow's estate was worth a lot more, Daisy would also still get those assets, and because the children potentially could be inheriting more of the estate, there could be immediate inheritance tax to pay. So it's really important that actually, if you want your spouse to inherit, or even if you want to split the estate between spouses and children, that you seek advice, because they can tailor it to your own estate, and to ensure that inheritance tax isn't payable on first death. Another scenario that we have is Dilip Bhai is married to Shantaben, and they have 3 children. Rajesh, who is married and has 2 young children and lives with Dilip Bhai and Shantaben. Deepa, who is married and has 1 young child and lives in Bradford. Dimple, who is single, is living the dream in Brighton and is estranged from her parents, as her parents do not agree with her life choices. Dilip Bhai dies in 2018 and leaves everything to Shantaben in his will. So quite straightforward. Shantaben then dies in 2020 and leaves everything equally between Rajesh and Deepa. So note that the will actually excludes Dimple in this will. But other than that, it's a straightforward will. The executors of the will are Rajesh and Deepa, but it transpires Rajesh and Deepa never got on. The house is worth 350. Shantaben died with investments of 300,000. She also had a piece of land worth 500,000 pounds with potential for development. She also had items of jewellery which total 50,000 pounds. We know she made no lifetime gifts in the last 7 years, and the reason that question is asked, because if she had done, then the amount not the gift itself, but the amount she had given away would come back into her estate for the calculation of inheritance tax. So if you remember last time, we did go over sort of the nil rate band, the residence nil rate band, and how it works. So basically, Dilip Bhai would have £325,000 of the nil rate band. He'd also have the residence nil rate band, which is presently £175,000, and Shanta Ben would have the same. And the reason that they would both have the residence nil rate band is because Shanta Ben is leaving the house to her direct descendants, i.e. to her children, so she can claim her husband's unused 175, have her own 175, and obviously the nil rate bands as well. So they basically have £1 million before any tax is payable. However, we know her estate is worth £1.2 million, and therefore there'll be £80,000 payable in tax. What are the issues here? So what could Shanta Ben and Dilip Bhai have done during their lifetime to mitigate inheritance tax? If you remember, we discussed if they wanted to retain some of the assets. Now, she's got £300,000 in cash. I mean, if she's in her late 70s or something like that, unlikely that she's going to need that kind of money. She also has a plot of land. Again, unlikely that she's going to need to do anything with that plot of land. So we can look at sort of transferring them as outright gifts or into trusts. The only thing we have to be careful of when it comes to land is obviously what will be the capital gains tax implications. And the reason that being because when you pass away, you get a capital gains tax uplift. So basically your beneficiaries inherit the land at the value at the date of your death, whereas when you gift a piece of land, you have to pay capital gains tax on the base value to the market value at the date of gift. And sometimes what you have to do is compare what the inheritance tax would be compared to what you're paying capital gains tax now. Again, these are, calculations that your accountant and your solicitor will help you guide you through to see whether that is worth making these gifts now, or how to kind of, balance those kind of taxes, because at the end of the day, the government doesn't want you to have your cake and eat it. So you will somehow, sometimes need to pay some tax. What about Rajesh, who lives in the house? Now, clearly, we talked about generational households last time, and I wanted to just stress this point again. It's really important that if you have a child living in your house or children, and some live outside, splitting the estate 3 ways, just a simple split, is not necessarily going to work. So you're going to have to think about, how will you protect Rajesh who lives in the house? It may be that you just give him a right of occupation for a couple of years in order to sort himself out, or you give him the option to purchase the house within the will so that actually he can use money from the other assets, which will, to pay for the house, and then Deepa gets it, because we know Deepa and Rajesh don't get on. So if we don't put an option to purchase in there, Deepa might just go, no, don't want to sell it to you. It gets complicated. So again, if your circumstances require has that kind of scenario, is definitely seek advice and see what's best in your situation. Do you kind of tailor the assets so Deepa gets a greater gift from other areas, or do we give him an option to purchase? Because he may not want to live in the house, we don't know, but at least it gives him some buying time in terms of if you allow him to live there for a certain period of time before the estate has to deal with the sale of the house or the purchase of the house by Rajesh. Clearly, Rajesh and Deepa don't get on. What could mum and dad have done? I think what we need to consider here are other lay executors, which could be your siblings, or we could consider professionals if you know that actually it would be better just to have someone completely independent to deal with the administration of the estate, i.e. after both of you have died, to sell assets or whatever. So clearly professionals will charge, but sometimes if your circumstances require it, I would strongly suggest that you have professionals as executors. Now, Dimple, she obviously hasn't been left anything in the estate. Now, because Dimple is a child of Shanta and Dilip, she has the ability to make a claim against the estate. So she falls under the criteria to be able to make a claim to say that she should have been reasonably maintained. Whether she will be successful or not is a different matter, but she does have to show that she was financially dependent on her parents, which in this situation she wasn't. But clearly any kind of claim against the estate means that sometimes, because they don't want to go all the way to court, the executors may settle. So what I would recommend is sometimes if you are going to leave a child outside, I would suggest maybe leaving them a legacy of a certain amount of money, and then saying that if they make a challenge, they also lose that legacy. But I'd also strongly recommend that if you're giving a reduced share or excluding a child, you write a letter of wishes of your reasons as to why you're excluding that child. And, you know, it could just be the fact that you've been estranged, you don't have any contact, and you want to reward your other two children. You're entitled to leave your estate to whom you wish. But what that letter will do, although it won't stop a claim, it will basically give reasons as to the format of your will, and allow your executor, well, help your executors defend a claim if it was ever bought. And we just need to consider in this situation where we have a multi-generational household, if it's Rajesh that passes away before Shantaben, and Shantaben hasn't done anything with a will, what will happen to Rajesh's wife and children? And actually, they need to be protected. So Rajesh clearly needs to do his own estate planning, make sure he's got life insurance if he doesn't have a property, in order for his family to be rehoused if Shantaben decides she no longer wishes to leave anything to Rajesh's children or wife. Another story. So this one is basically Abbas, Zainab are married and have 4 children, Qasim, Ali, and Zara and Layla. Abbas owns a heating company with his brother Khalil, and both are equal shareholding directors, and the company value as a going concern is worth £750,000. It is a limited company, but there are no shareholder agreements in place, and the eldest 3 children are over 18, and none of the children work in the company. So the reason I've brought this one up is if we just discuss their assets, and I'll explain why this might suit some of your circumstances. So they have a house worth, so Abbas and Zainab have a house worth £500,000. They have savings of £300,000, life insurance payable on first death, Rolex watches worth £30,000. And as we said, Abbas's shareholding in the business is worth £375,000. So Khalil, who is Abbas's brother, may not want Abbas's children or wife to be involved in the business if Abbas died, or vice versa, because simply they lack the expertise. They have no heating expertise at all. So in a straightforward will, Zainab will inherit the estate and therefore Abbas's shareholding, but Zainab has no idea how to run a business or bring clients in or anything to do with heating at all. What will, in that situation, what you have to consider, well, actually, if there is this business, how will Khalil pay Zainab for Abbas's half share, especially if the company doesn't have sufficient cash balances? So we know that, you know, it may be worth this much, but actually it's just a trading business. It kind of doesn't have a sufficient cash balance. How will Khalil go, well, actually, Zainab, I don't want you to be involved in the business. I want to just run it myself. But actually you're going to be half a shareholder now, but I don't have any money to buy out your shares. What would happen then? So what we would suggest that whilst all shareholders are alive, your company purchases what's called a relevant life policy in both Abbas and Khalil's life. You also purchase a key person policy. So because obviously Abbas and Khalil are key players, Abbas will have his own role, Khalil will have his own role. If you remove a key player, the market will know that actually you've removed a key player, and basically the value of your business can fall. Your your customers may go elsewhere. We don't know. So if you actually can have a key person insurance, you can quickly bring someone in from the market, because you've got sufficient money which was paid by the insurance. The relevant life policy will also pay for Abbas's share, which will then can be basically used to purchase the shares from Zainab. I've just briefly mentioned shareholder agreement because you'll need that in place if you have this, or a partnership agreement if you're a partnership, because you've got to direct how who's allowed to buy the shares and that sort of thing. What Abbas will do in his will, it will allow the business shareholding, actually the shares themselves, or the funds used to purchase the shares, to be put in a trust. And the reason we're doing that is because if you remember last time I mentioned business property relief, what we're trying to do is we're going to capture business property relief on Abbas's death because we know Zainab isn't going to carry on the business, so we can ring fence it. Everything else can be left to Zainab. So what I've done here now is actually just quickly work through some potential inheritance tax complications if you don't do it the way I've suggested. So Zainab on her death will have, if she follows our advice, a house worth £500,000, savings of £300,000, the Rolex watches. So her estate is worth £830,000. Given that she's actually got the nil rate band and the residence nil rate band, that falls under the allowances, and therefore there'll be no inheritance tax to pay on her death. However, Abbas's shareholding, what we're doing is, because we're directing into trust, getting the BPR, and we'll also be suggesting the life insurance should go into trust. So again, Zainab would have access to that money, but it doesn't form part of her estate on her death. Her estate is reduced. However, if we gave everything to Zainab, so we gave her the shareholding, which actually would become money because she's not going to carry on the business, all we're doing is increasing it by £475,000 and then giving her an inheritance tax liability of £122,000 on death. So this is where you can actually, this is called estate planning. This is what you're doing by your will to make sure that any reliefs are captured, so that actually you're, on second death, where in a husband and wife situation, or even if you're a single person and you have a business, those funds aren't aggregated with that second person's death, so that actually inheritance tax doesn't become payable. I just briefly wanted to mention, if you have a son that works in the company, and for example, Qasim is the eldest son, he works in the company, nobody else does, and Abbas wants to leave him the shareholding because in the last few years he helped the company grow, you can lifetime plan. You can either, include Qasim as a shareholder. Again, there will be considerations because you're going to be gifting a certain percentage of your shareholding, whether there will be any capital gains tax. You can even actually put a shareholding in trust. But again, more complex issues, just food for thought. These might be things that you might want to do. And again, you will need to seek professional advice if you're looking at sort of, gifting some of your shareholding to a child in order for them to be able to basically have involvement in the business. In terms of, as again, in a will, you can specifically leave a shareholding to a son as well, but obviously on balance, you'll have to look at, if you want equality between children, for example, that you are maybe leaving a greater share of assets to other children. But again, you will be directed to sort of how to do this when you seek advice. Now, this long-term care planning, I got a couple of questions actually last time, and I know long-term care planning, especially I see a lot of people who are concerned about care home fees. I think one of the things I want to stress at the outset is that if you need residential care and you do not have sufficient assets of your own, you will go into local authority care home. And I've been into them and they're not great. Some of you may have visited people in them. Unfortunately, they're not very nice. And it's because you don't have the funds to choose where you go. It's the local authority chooses where you go. So I appreciate that you want your children to inherit and you don't want your estate to be dissipated in care home fees. But balance that with the fact that if, unfortunately, this is your hard-earned money at the end of the day, if you go into care and you don't have sufficient assets because you gave them away, then you won't get the best care possible. But of course, we do give advice on this. And one of the things is that in terms of assessing your contribution towards care home fees, your main residence will not be used to calculate your contribution in the following circumstances. So if you and your husband live in a house, and one of you needs care, the house is just completely disregarded. It's also disregarded if a dependent of yours over the age of 60 lives in the house and it's their main residence. So if, it's mom and son, for example, and he's 60 or over, The house, again, will not be used in assessment of contribution towards care home fees. It also won't be used if someone who is incapacitated, which basically means, you know, someone who has a disability, and although this isn't defined in the 2014 Care Act, it usually means someone who's claiming some kind of disability living allowance, PIP, that sort of thing. It also won't be counted as part of your contribution towards care home fees. Everything else that is your assets will be accounted. So even if you have joint accounts, your half share will be used to calculate your contribution. The same with any sole assets. So if you have other property, etc., that will be used to calculate your contribution towards care home fees. So what can you do? There's quite a few things that you can do, actually. There are lots of risks with doing it, and I'll just highlight them. If you are considering these options, again, I'm just alerting you to the information here, but again, seek professional advice, because the risks sometimes outweigh the benefits, and it will be on your own circumstances. So one of the things you can do is obviously just gift your house to your children now. It means it will no longer be your house. You will have no control over it. If any of your children die, become bankrupt or divorce, it will form part of their estate. And also it will mean it's their second home as well. So at the point of gift, when they come to, once they've received that, and if after your death they sell it, it's at the point of gift that they received your house. So they will have potentially a capital gains tax, whereas if they received it on death, they wouldn't have that necessarily. We strongly advise against doing this. I never ever advise, I mean, we do it because people are strongly want to do it, but I always don't advise clients to do it. And the reason being, because it's their security, it's their home. They may fall out with the children, and there could be a forced order of sale of the home. The second option, and a little bit more safer, is place your house into trust. So this could be a lifetime trust, so that you get to life to live there. It could be what we call a discretionary trust, so you have the option to live there. Again, you will no longer own the house, but it's the trustees and the trust, well, it's the trust that owns the house, and the trustees, which could be you and maybe your children or other lay individuals, manage that house on your behalf. So you're not free to do anything with that house without the consent of the trustees, but you continue to live there, you'll pay the bills. It's like as if nothing's changed, but actually the house is now held in trust. The benefit of doing that is that no one can force to sell it. All the trustees will make a decision about what's the benefit, and your letter of wishes will explain, actually, especially if you've got a life interest in there, that you will continue to live there until you die, and subsequently the house is sold and distributed however you want it to. I think I'm going to mention, actually, at this point, just miss the cash asset, is that if you do any of these two options, I think the biggest thing that you have to be sure of is your loss of security, because you no longer own the house, but also actually the whole thing can just collapse because a local authority may think that you deliberately deprived yourself of an asset. So if they see that actually, you get diagnosed with dementia, and then, I don't know, 2 or 3 weeks later, you make these kind of gifts and then subsequently need care, they're going to go, well, actually, what happened to that house, and why did you do that house? They're really under-resourced. These challenges are much more stronger now than they used to be before. But clearly there is no time scale, but the longer the time goes between you making a gift to, you needing care, then the less likely they can actually say that you foresaw care. I mean, they can always make a challenge. Whether it's successful is not a difference. Some of ours have been challenged, and we've been successful in defeating them because of the fact that the actual note said that the reason for the transfer was, to make the administration of the estate easier for the children after death, because when a trust owns the property, what it means is that actually the trustees don't need a grant of probate. They can just simply, as trustees, sell the house. And if there's not much else in the estate, they will never need a grant. And it's kind of just arguing the fact that actually the individual never foresaw care. But it's a very big risk, and it's one that you need to be aware of if it's something that you want to move forward with. And again, if you have inheritance tax issues, if you actually put your house in trust or give your house outright to someone and you continue living there, it will always form part of your estate for inheritance tax. So basically you can't have two chunks of the bite. So there are ways to make sure that you don't have to pay inheritance tax, but again, those are things like you can pay market rent to the trustees or to kind of say that actually you're renting that property now. But again, you would need to seek specific advice in relation to your own circumstances. Another option is to do it if you feel actually, oh sorry, I forgot to mention the sufficient cash assets. If you have quite a lot of cash, like £300,000 in the bank or something, you can make lifetime gifts of those cash assets, which will reduce your estate. So although if you don't want to gift your house, for example, you've given gifts of your cash assets because you have sufficient income to live off yourself and you don't need that. I mean, that's one thing you've got to be sure of, that you will never need that, because once you gift it, the gift is gone. You've got to, that will reduce your estate. So if you do need long-term care, again, obviously it's just your house that perhaps may be left in your estate with a small amount of cash funds. If you don't want to do any of those, you can do it by will. So obviously where this would only work, obviously where you're husband and wife or cohabiting, whatever, that if both of you needed care, then clearly the house would be used. But if one of you died, it would only, and then there was a survivor view, there is a way to do wills in which actually only half the share of the house or half the share of your assets are used to pay towards care home fees. And the way to do it is like, if you own your house as joint tenants, then I'm conscious that I've nearly finished. I'll just be a couple of minutes more just to finish this off. If you own your house as joint tenants, you can sever your joint tenancy, so you own it as 50-50 shares. So distinct, so husband owns 50 shares and wife owns 50 shares. Nothing really changes, it's just basically just says how you own the house. Joint tenants means that actually if you die, the house automatically transfers to the survivor of you. Whereas if you hold it as 50-50, your half share can go by the terms of your will. So in your will, what you would do is actually give your half share of the house to your children, for example, or your beneficiaries, and then allow your spouse to live in your share of the house for as long as they can. But if they needed residential care, what we've done is we've actually ring-fenced the first person's share of the house, and the survivor's share can only be used to pay towards the contribution of care home fees, because actually in your will you said, I don't want to leave my house to my spouse, and a lot of people do this when they're in blended families because they want to make sure their own children from their own relationships, previous relationships, inherit. But actually what we're saying is that the person that survives can live in that house. They can even sell that house, downsize, whatever. But actually, ultimately, the capital in that house will always be for the children. It will never form part of the estate of the survivor of you. So if they needed care, then only their share of the house would be used to pay for that care. We can also do that with assets. We just have to balance inheritance tax in this issue, but again, it will be tailored to your specific needs. So a lot of people go with the second option because clearly when a lot of people don't want to give up their house. It's their own security, especially if it's the only asset they have. And if it's not the only asset they have, I would suggest making gifts of other property or other assets if you are worried about long-term care planning. But clearly you may have an inheritance tax liability, so it will go hand in hand. And yeah, that's it. Thank you for listening. So if you have any questions.